Welcome to Term Talk, the video podcast from the Federal Judicial Center that analyzes Supreme Court decisions from each term likely to have the most impact on lower courts. I'm Francesca Williams, education attorney for executive education at the Federal Judicial Center. Joining me to do that are Laurie Levenson, professor and David W. Burcham chair in ethical advocacy at Loyola Law School, and Evan Lee, Emeritus professor at University of California Law, San Francisco. Thank you both for being here today. Let's get started with Erlinger v. United States. This case involves sentencing enhancements under the Armed Career Criminal Act, ACCA, for prior convictions. Laurie, what are the issues and facts of this case?
Francesca, as you said, this case involves the Armed Career Criminal Act, and it imposes lengthy mandatory sentences on defendants who have been convicted of 3 or more prior violent felonies. Some would include serious drug offenses. Now, the question here is whether you have offenses in this case that are committed on separate occasions, and that's what triggers this enhancement. Within that question is the issue of who determines if they're separate occasions, the judge or the jury, and what will be the standard to determine that. So when it comes to the facts of Paul Erlinger, he was charged with being a felon in possession of a firearm unlawfully. Now, ordinarily, he would face a 10-year max, but under ACCA, that changes to 15 years to life in prison if the enhancement applies. He ended up pleading guilty, Francesca, to the firearm charge. He said that these old convictions were for things like burglaries. He burglarized a pizza shop 26 years ago, stole from a separate sporting shop. He said those shouldn't be used as enhancements because, in fact, they're not separate. That went before the district court judge, and at sentencing and resentencing, he was considering whether he should look at these convictions. The district judge said he had to apply the mandatory enhancement, and he was rejecting the defendant's argument. So that's an overview of what happened in this case.
Thank you, Laurie. Evan, can you speak to how the court analyzed these issues?
Sure. The court's opinion in Erlinger cites cases from 2 distinct lines of authority regarding federal sentencing, and I think it's best if we keep track of what's what. There's a line of cases dealing with the question of who decides which sentencing facts. Is it judges or juries? That line of cases includes Apprendi versus New Jersey, Align, and Almendarez-Torres. Then there's another line of cases dealing with how judges go about finding the only fact that they are allowed to find, which is the fact of a previous conviction. And that line of cases includes Taylor versus the United States, DeCamp, Mathis, and Shepard. Shepard versus the United States is the 2005 decision in which the court held that judges may consult charging documents, jury instructions, plea agreements, plea colloquies in applying what has come to be called the so-called, the modified categorical approach that was explained in the DeCamp opinion and the Mathis opinion. So this case, Erlinger's case, falls into that first line of cases. Who may decide which sentencing facts? Apprendi held that the fact underlying any sentencing enhancement that would push the punishment above the statutory maximum must be found by a jury and not a judge. And in that case, the enhancement was for racial motivation in a shooting. Align extended the holding of Apprendi to any enhancement that would raise a mandatory minimum sentence, which is, of course, what we have here in Erlinger. And in Align, it was the prior involved was brandishing the weapon that the felon illegally possessed. But neither Apprendi nor Align overruled the previously decided case of Almendarez-Torres, which had held that judges and not juries are entitled to find the fact of a previous conviction. But here in Erlinger, the court said there's nothing in the Shepard case, there's nothing in that opinion that licenses judges to look at those sources for the purpose of determining whether a group of prior convictions was committed on the same occasion and therefore constitutes only one predicate offense for ACCA purposes, or on different occasions and therefore constituting multiple predicate offenses. Shepard is strictly limited to determining what statute or statutes the defendant was convicted under.
Thank you, Evan. Laurie, what did the court hold here?
The court held that there should be a jury to make the determination regarding the prior convictions. There are just too many underlying facts about the time, the place, the participants that need to be found before you can decide whether these offenses were committed on separate occasions or a single occasion. So the majority said this is something that should go to the jury. Chief Justice Roberts concurred, but he said if there's an error in this case, it could be harmless. And then there was a concurrence by Justice Thomas, who said basically we should just overturn Almendarez-Torres at this point.
Laurie, what should the lower courts know about the dissent's arguments?
Well, they should know that Justice Kavanaugh, joined by Justices Alito and Jackson, said, there really are no issues with Almendarez-Torres. It is still good law, and a judge should be able and can decide whether there are prior convictions under the recidivism law, that history has allowed this type of determination, and it ended up being a well-settled practice. It's interesting because Justice Jackson said that, frankly, we should probably overturn that line of Apprendi cases that Evan was discussing, that under the 19th century, sentencing laws are not sacrosanct, those laws, that we need to have some legislative innovations in sentencing. And that's one way to attempt to remedy, for example, things like racial disparities in sentencing. So she thought that, frankly, judges are better equipped to decide the issues surrounding recidivism.
Very interesting. Any other takeaways from this opinion, Laurie?
If you boil it down for the district court judges under the ACCA, any issues beyond the fact of the conviction must be decided by a jury, and the judges should probably bifurcate the proceedings to protect the defendant from prejudice.
Thank you so much for that. Let's move on to Pulsifer v. United States. The opinion resolved a circuit split about what Congress meant when they used the word "and" in a statute meant to give some defendants relief from mandatory minimum sentences. Evan, would you describe the facts and issues in this case?
Well, as everybody knows, during the 80s and the 90s, Congress passed a number of laws that set up so-called mandatory minimums for a lot of drug convictions. And that ended up producing roughly a doubling in the prison population in less than a decade. During the Trump administration, Congress passed the First Step Act, which includes a provision known as the safety valve provision in 18 U.S.C. 3553F. And in order to qualify for this safety valve provision, defendants have to meet 5 criteria. This case involves the interpretation of one of those 5 criteria. And honestly, the provision is made much more difficult to follow because it's couched in negative language. Subsection F1 of 3553 states that a defendant qualifies for this safety valve relief if the court finds at sentencing that the defendant does not have A, more than 4 criminal history points, excluding any criminal history points resulting from a 1-point offense as determined under the sentencing guidelines, B, 3-point offense as determined under the sentencing guidelines, and C, a prior 2-point violent offense as determined under the sentencing guidelines. So there you have a laundry list of 3 items, and the last 2 are connected by the word and. And what this case really comes down to is, what's the meaning of and? Does it essentially mean that a defendant, in order to get the safety valve relief, merely has to satisfy one of those 3 provisions, or must satisfy all 3? So in this case, Pulsifer pleaded guilty to drug possession in 2020, and that would be a mandatory minimum of 15 years unless he qualified for safety valve relief. He had 2 priors that satisfied subsections A and B, but not C. So this is one of those cases where it really makes all the difference whether defendants have to satisfy merely one of the 3 or all 3 in order to get safety valve relief. He argued, obviously, I only need to satisfy one of those 3. And he had 3 circuits behind him at that point: the 4th Circuit, the 9th Circuit, and the 11th Circuit. The government made the opposite argument. It said, no, that's not the meaning of and. The meaning of and in this provision requires that a defendant meet all 3 of the items in the list. And the government was backed up by 4 different circuits at the time: the 5th, the 6th, the 7th, and the 8th. And the district court agreed with the government, as did the 8th Circuit. The Supreme Court, by a vote of 6-3, with Justice Kagan writing, agreed with the government.
Laurie, can you walk us through the court's reasoning, please?
Well, the court started out by using rules of grammar and definitions and common usage, and then ended up using examples like from the Hungry Caterpillar, when you have language that says ate through 1 piece of cake, 1 ice cream cone, 1 pickle, 1 piece of watermelon. What does ate through apply to? All through all the pieces of the cake, ate through everything, and not treated as one thing. But the dissent, frankly, didn't like that type of frivolous example and said, let's look at Article 3. In Article 3, judicial power extends to all cases arising under the Constitution, the laws of the United States, and treatises. Any of those kinds of laws, not only cases that arise simultaneously under all 3 kinds of laws, would be covered. So you could find examples that go either way, and the majority eventually went to look at all the paragraphs in context to see how they relate to each other. Here, it only makes sense to treat the statute like a checklist. These are gatekeepers, how serious the prior offenses are, and you don't get the safety valve unless you meet all these requirements. Otherwise, A is just superfluous to B and C. Moreover, the court said it's not going to apply the rule of lenity because they didn't think the statute was ambiguous when read in context. They thought that, in fact, you had to read it this way as a checklist in order to get the benefit first step.
So Evan, Justice Gorsuch wrote a dissent. He was joined by Justices Sotomayor and Jackson. How did they analyze this differently?
Well, they disagreed on the grammar, and I think they really focused in on the word and versus the, what they could have used or. They said Congress knows how to use the word or. They use it in a whole bunch of other places. If they'd meant or, they would have said or, but they didn't. They said and. I think the overall tenor of this dissent, though, has to do with kind of the big picture involving federal sentencing. And it may say something important about the way these 3 justices, Gorsuch, Sotomayor, and Jackson, view the overall picture of determinate federal sentencing. Justice Gorsuch says, look, the overarching purpose of the First Step Act was to reduce the harshness of mandatory minimum laws. And he cited some statistics saying that the number of cases in which individualized sentencing decisions by district judges are allowable were tiny, that it was a very small number before the First Step Act, that if you adopt Pulsifer's view of this question, it would significantly increase the number of cases in which district judges could exercise individual discretion in sentencing. But with the majority having chosen the government's interpretation, the number of cases in which district judges may make individualized sentencing decisions is only very modestly increased over the status quo ante of the First Step Act. And so I think the overall tenor of this dissent is real disappointment that the guts of the First Step Act aren't being honored.
So, Evan, takeaways for the lower courts.
Yeah, I mean, if I were a district judge, I don't think I'd get too wrapped up in the hungry caterpillar or the rules of grammar here. I think it's basic. I think the takeaway is, in order to qualify, under 3553F, a defendant has to meet all three of the items on the laundry list and not just one.
Thank you. Laurie, what do you think the district judges should know?
I agree with Evan. And, it's hard to apply this discussion to the interpretation of other statutes. I think they should know that under this opinion, using the legal analysis of the majority, it does limit the application of the safety valve. And when they have one of these cases, the defendant is not going to get the benefit of the safety valve unless they don't have A, B, or C. They can't have any of those to get the safety.
Well, thank you both for joining us and helping us sort through these complicated issues.